Thanks to Audible for keeping LegalEagle in the air.
Research suggests that PTSD can be triggered by new stressors.
Like losing your family.
I need to get to work on the opening statement, but we need to be sure Castle will get on board with this.
I'll try.
So, have they not spoken to their client before? Pro tip, if trial is tomorrow, you really, really, really need to talk to your client beforehand to know what your defenses are going to be. Hey Legal Eagles, it's time to think like a lawyer. Today we are covering the trial of Frank Castle from Marvel's Daredevil. We've been on a bit of a Marvel tear here on this channel, but before I leave the Marvel legal cinematic universe, at least for a little while, I wanted to make sure that I covered this highly requested scene from Daredevil where Frank Castle is put on trial for all of the murders that he has committed, and he is being defended, spoiler alert, by Matt Murdock, who is also Daredevil on the side. Lawyers gotta have a side hustle, I guess. As always, be sure to leave your objections in the comments, which I'll either sustain or overrule, and stick around until the end of the video where I give the trial of Frank Castle from Daredevil a grade for legal realism. So, without further ado, let's dig into the trial of Frank Castle on Daredevil. All right, this is kind of an interesting scene that you don't see all that often in legal procedurals. It takes a long time to get a defendant out of the lockup to be ready for a court appearance. And often if court appearances are at 8 or 9 a.m., then you might have to wake up at 3 or 4 o'clock in the morning and be transported from the jail over to the courthouse where your hearing is going to take place. So we actually saw this in the Paul Manafort trial not too long ago, where he waived his right to appear in person so that he wouldn't have to go through all the rigmarole of getting woken up, being transported, which can take hours from the jail to the courthouse, and only to have some sort of procedural hearing take place. And that's why often you'll see defendants waive their right to appear in court and you just let the lawyers take care of it, unless it's really important that the defendant be there, like the trial is starting.
I get my hands on the worthless intern who organized these files.
I'm sure that intern's just following the DA's orders. It's not officially sabotage, just sets it back.
It's a cheap trick.
We got bigger problems, like locking a defense. McNaughton still our best bet.
What's that?
The insanity
plea.
Whoa, guys.
We need to buy a not guilty verdict. Our high school debate team could prove that Castle did it.
Okay, a couple problems here. Number one is that an insanity plea is very, very unlikely to work. The other problem is that New York actually does not follow the McNaughton rule. New York follows a modified version of the Model Penal Code. The Model Penal Code is a theoretical rubric for potential criminal laws that was created by a bunch of American scholars who saw that there were some issues with some of the antiquated laws that the United States had at the time. And so they put together what they thought would be a model penal code for the country. And New York adopted a version of the test that's laid out by the Model Penal Code. The New York law requires that a defendant prove by a preponderance of the evidence, because it's an affirmative defense, that at the time that the defendant committed a crime, that he or she lacked substantial capacity to know either 1, the nature and consequences of such conduct, or 2, that such conduct was actually wrong. The defendant can prove either prong and meet the requirements of the insanity defense, but they have to prove that by a preponderance of the evidence. So it's up to the defendant to prove their insanity defense. Now, preponderance of the evidence is generally the standard that we use in civil law. It just means more likely than not. So if you had both sides on a scale, the side that had slightly more weight than the other one, that is a preponderance of the evidence. So it can be 51%. That's enough to tip the scales in your favor. If you are the defendant in a criminal case, you want the prosecution to have all of the burden, and they have to prove all of the elements of their case beyond a reasonable doubt, which is a much, much higher standard than preponderance of the evidence. So that's the second issue with Matt and Foggy deciding on whether to make a McNaughton defense in this case. It doesn't work in New York.
Okay, and either way, we need an opening statement tomorrow.
I can open with PTSD as a mitigating factor, focus on Castle's time at war.
So you think the war has made what Frank what he is?
Our only goal is to reduce the charges and set precedent. Castle made a lot of enemies, all right? If he goes into general population, he's as good as dead. We need to get him somewhere safe where he can get help, and citing PTSD could do that.
I mean, none of us know what Castle saw over there. But research suggests that PTSD can be triggered by new stressors.
Like losing your family.
I need to get to work on the opening statement, but we need to be sure Castle will get on board with this.
I'll try.
So, have they not spoken to their client before? Pro tip, if trial is tomorrow, you really, really, really need to talk to your client beforehand to know what your defenses are going to be.
All rise. Court is now in session.
All right, looks like a pretty reasonable facsimile of a New York courthouse.
Indictment number 1986, 4447, the People versus Frank Castle.
Be seated.
Looks like you're a man down.
Ladies and gentlemen of the jury, the defendant has been indicted for several serious crimes, but I'm instructing you as a point of law that an indictment
those college stress streams? When you show up to class in your underwear? That's me right now. God damn. Matt was supposed to deliver opening, not me.
Ms. Reyes, are the people ready to begin opening statements?
I like that the judge has already started instructing the jury here, because so much of what happens in an actual trial is really opaque to members of the jury. And so the judge always is trying to do his or her best to hold the hand of the jury to make sure that they understand what's going on and they don't prejudge anyone just because they happen to be accused of some crime here. Now, it's odd that Frank Castle is still in his orange jumpsuit and he is shackled to the table. If you were worried that he was prone to violence and was a threat to someone, that would be a reason to actually keep him in chains. But even under those circumstances, you would still probably let him wear a suit to court so that he can at least look semi-respectable and not like an actual criminal at that point.
Ladies and gentlemen of the jury, Frank Castle brutally tortured and murdered 30 people. 30 that we know of.
Oh man, it's very argumentative for an opening statement.
Acted as judge, jury, and most violent executioner.
She's way too close to the jury, did not ask for permission to enter the well.
And you will hear that the defendant's victims were criminals. But the victims are not on trial here today. And justice does not belong in the hands of a man like Frank Castle. This isn't the Wild West. Justice is served here, in a court of law. And it is up to each of you to take back the city from lawless vigilantes.
This is a pretty improper opening statement. An opening statement is your opportunity to give the jury a preview of what your case is going to show. It's your opportunity to establish a theme, but mostly it's not for argument. It is for an opening statement to show what you intend to prove and to set the guidelines. But at the same time, you're not allowed to overly personalize the jury and make the jury overly emotional, especially in a capital murder case like this. The defense should really be objecting here because it's pretty improper.
Mr. Nelson, are you prepared to make your opening statement?
She's good.
No, she's not.
Mr. Nelson? Mr. Nelson, are you reserving the right to make your statement at a later time?
Ooh, that's super cool. Yeah, okay, so what the judge asked there is a really interesting piece of trial procedure that actually does exist in the real world. The defense has the option to reserve their opening statement for the start of their case in chief. And if at the end of the prosecution's case, they have not at least shown beyond a reasonable doubt that the person being accused is guilty, then they have effectively failed and you can move for what's called a directed verdict or a JNOV, which stops the trial right there because the prosecution didn't meet their burden. Now, you are allowed to reserve your opening statement so that you can say that, okay, well, if the prosecution has met their burden in the first instance, now we're going to do our best to take the ball from our side of the court and throw it back to the prosecution. And at that point, you can lay out what your entire case is going to be in your own opening statement. There are strategic reasons why you would do this. Number one, if you don't have a particularly good case, you might reserve your opening statement to a later time. If you feel like the prosecution is really not going to be able to meet their burden, you might reserve your statement for later to put all of the focus on the prosecution's case. And given that lead trial counsel hasn't shown up, reserving your opening statement is probably a good way to go here.
So, you're 19, standing in hot sand, sun burning down, noise, yelling, gunfire. The only thing that you know for sure is that you're surrounded by an enemy that wants you dead.
I don't know that this is necessarily argumentative. I mean, he's sort of talking about facts, and if he'd preface this by saying that the evidence will show this, this, and this, you could probably get away with it. The problem is that in a case like this, the last thing that you would want to do is bring in character evidence. I don't think that, number one, that's relevant. And number two, when you do that, it opens the floodgate, and man, the prosecution would just bring in witness after witness showing Frank Castle's bad character. So I think there are some big strategic problems with Foggy's opening statement here.
But you do it. You endure it. Why? Because you have orders. And you have a duty.
What does that have to do with anything?
Your life doesn't end here. You have people you love waiting at home. Because aside from being a decorated Marine, the man before you is a good husband and an excellent father.
Okay, so he's going hard into the good character right now.
Returned from the hell of war, wanting nothing more than to pick up his life. But his wife, young son, and daughter were brutally murdered by criminals. And no one, not the police, and certainly not the district attorney, stepped up to make it right. See, Frank Castle never came home. He just traded in one war zone for another. This trial is...
Matt Murdock shows up. Way too late.
It's about the failure of the justice system. And how one man, Frank Castle, is being used as a pawn to cover up that system's mistakes.
Huh. So that's not a great theme. I mean, it's okay. You want to focus on the government's burden to prove their case beyond a reasonable doubt. But Foggy hasn't given the jury something to hang their hat on. If you can rely on good character and that's all you have, then that's all you have. So you go after Frank's good character and you say that that's a mitigating circumstance. But yeah, I don't think that's a very good opening statement.
Where the hell have you been?
Look, I made a mistake, Karen. I feel terrible about it. But Foggy, I called someone's opening statement. You did great.
It was amazing.
Hey, thanks for keeping us afloat, buddy.
Okay, so if you are lead trial counsel in a capital murder case, I think missing the opening statement that you were supposed to give is probably grounds for malpractice. I wonder if Daredevil, Matt Murdock, is canonically a good lawyer in the comics. You know what? Let me get an expert on this. Hey, Matt, can you help out a sec?
Thanks, Devin. As a longtime Daredevil fan and fellow Matt myself, I feel uniquely qualified to say that Daredevil should be one of, if not the greatest fictional lawyers of all time. He's very intelligent, graduated from Columbia Law School. He's also an amazing detective, and most notably, the accident that blinded Matt as a child gave him heightened senses, one of which is super hearing, which he's able to use to his advantage during trials. Matt can hear a heartbeat from across a room, which he uses kind of like a human lie detector. He can tell if a juror is on his side and potentially change his argument to win more support. He can also tell if a witness is lying or telling the truth. He's essentially psychic. However, the biggest obstacle between Matt and legal success is frequently Matt himself. He has a strong sense of Catholic guilt that often forces him to take on lost causes that he can't win. Also, Matt's double life as Daredevil forces him to split his time between being a lawyer and a vigilante, which in some cases has forced him to lose clients and even lose cases. In conclusion, based off the comics, when you take into account his intelligence and his super hearing, Matt Murdock should be one of, if not the best fictional lawyers of all time.
Thanks, Nando. I guess now I know never to hire Matt Murdock.
Dr. Gregory Tepper, how long have you been medical examiner for the city of New York?
14 years, give or take.
And how many death certificates would you estimate you've signed in that time?
I don't,
That's probably in the tens of thousands.
Objection, Your Honor. Leading the witness.
Oh my God. That is such a stupid objection. Cross-examination is supposed to be all leading questions. And on top of that, this would be a really, really softball question for a medical examiner. A medical examiner testifies a lot. I mean, part of their job is to testify in these kind of criminal cases. So they're gonna have a lot of experience, especially someone who has been the medical examiner of the city of New York for 14 years. So he would have a ballpark figure for the number of death certificates that he signed a lot, because that's a question that's going to come up in a cross-examination like this, where you're allowed to lead the witness.
I have something I need to say.
Doctor?
Your Honor, I'm sorry, but I have to. On the record, I need to say something about what I did.
Clear the gallery.
All jury members, please exit back to the deliberation room. Everyone in the gallery, please make your way out of the courtroom at this time.
Why are they taking Frank Castle out? He's the defendant. He definitely gets to stay at this point.
Your Honor, I believe the defense intends to distract the jury and make this case about some impossible to prove conspiracy theories.
Impossible to prove. You and me just confirmed that he doctored the autopsy report.
He also
Yeah, Murdock is totally right there.
office finds out that your firm had anything to do with this.
Our firm? For all we know, it was you who sent those goons.
I've heard enough. It's clear to me that whatever Dr. Tepper may know about these autopsy reports has been tainted by threats made by person or persons unknown.
Then the defense asked for a mistrial.
Not on your life, Mr. Nelson.
What?
I'm not convinced these documents, whatever they may be, are even relevant to this trial. I'm striking the doctor's entire testimony and instructing the jurors to disregard anything they may have heard.
Okay, a couple of different things going on here. The judge is probably right that the medical examiner's testimony about Frank's family is not relevant. That being said, in this particular trial, this is the medical examiner that not only examined Frank's family and conducted the autopsies on Frank's family, but he also conducted the autopsies on all of the victims. The medical examiner has been testifying for probably days. I mean, I know they're showing it as a matter of hours, but this kind of testimony over the deaths of 17 people plus Frank's family, that's gonna take days. And it's going to be a very, very important witness for the state. It's incredibly unfair, I would say clearly prejudicial, for the state to be able to show the jury the testimony of this medical examiner and then prevent the defense from being able to cross-examine the medical examiner. You are constitutionally allowed to face your accusers. And it's crazy for the judge not to declare a mistrial right now. The jury has been tainted. You can't unring that bell. And there's no way to go forward. I think if you were the prosecution, you'd be pissed too, because without the medical examiner's testimony, I'm not sure how you prove up your case.
I wonder if you could tell us how Lieutenant Frank Castle won the Navy Cross.
Due to the nature of that mission, you'll have to understand that precise circumstances are classified.
How about the part that's not?
Lieutenant Frank Castle was part of a small team that was conducting a close target reconnaissance in the vicinity of the Hindu Kush. The mission became compromised, taking enemy contact on 3 sides. Lieutenant Castle wanted to abort, said the mission was a bust, pulling the plug would save lives. Officer in charge said no.
I feel like this is that scene out of Airplane where the wife is asking Stryker about what he's going to do, and he says,
"My orders came through. My squadron ships out tomorrow. We're bombing the storage depots at Daiquiri at 1800 hours. We're coming in from the north, below their radar."
And she says,
When will you be back?
I can't tell you that. It's classified.
Precise circumstances are classified.
It really seems like this character has just talked about a whole bunch of classified information, and there can't possibly be any classified information left that he hasn't already divulged to the jury.
My father served in Vietnam. Do you know what he told me about medals?
No, ma'am.
He said the only people who truly know what happened are the ones that were there. He told a nice story, Colonel. But how can we know that it happened the way you described?
Well, perhaps I wasn't clear. I was there, ma'am. That officer that didn't listen to Frank, got his men trapped. You're looking at him.
This is a great dramatic scene. I mean, regardless of legal accuracy, I love the turnaround here. This is a great example of the legal truism that you do not ask questions on cross-examination that you don't already know the answer to.
Are you aware that Frank Castle's wife, son, and daughter were all murdered right in front of him when he sustained the brain injury in question? An injury which you say keeps him in a perpetual state of mental and emotional chaos.
I am, yes.
With that in mind, would you say that Frank Castle's mental state satisfies the definition of extreme emotional disturbance?
Objection calls for a conclusion.
Your Honor, Dr. Lee is an expert on the brain. He is qualified to an opinion, and said opinion is not only relevant, but imperative to the case.
Okay, so this is a really interesting objection here. I think they're a little confused on the terminology, but this kind of objection makes sense. So you are allowed to call experts, and experts are allowed to opine in a way that lay witnesses are not allowed to opine when they testify. That's really the whole point of an expert. That being said, generally speaking, witnesses are not allowed to opine as to what we call the ultimate issue in a case. So you can't ask a witness, do you think the defendant is guilty? Well, guilt is one of the ultimate issues in a case. And if you are arguing insanity, for example, you can't say, does that mean that the defendant is actually insane for the purposes of the insanity plea? Because that's the ultimate issue, and only the jury is able to decide the ultimate issues. If emotional disturbance is an ultimate issue for the trier of fact, then it would be improper for the expert to opine. But if emotional disturbance is a neurological term that is sort of a stepping stone for whatever legal issue that they are trying to prove, then it would be okay for this neurologist to make that testimony.
Mr. Castle, you've been charged with multiple capital crimes. Been called a killer incapable of empathy or remorse.
No. So I hear.
Frank, may I call you Frank?
Yeah.
It's good. You want to humanize your defendant?
Frank, we've heard a lot about neurochemistry and psychology and all things unfolding scientifically and otherwise inside your brain. But I just have one question I want to ask.
I hate it when people say they have one question, because it's never just one question.
What happened that day? The day your family was so tragically killed? It's okay, Frank. I understand it's difficult.
Do you? Do you understand? Because I don't think you understand shit.
Like permission to treat the witnesses hostile, Your Honor?
Okay, so this is actually a good example of when you can actually treat a witness as hostile. It's a request that's made in legal dramas all the time, but they usually get it wrong. Here, they basically get it right. All it means to treat a witness as hostile is to be able to ask them leading questions. Yes, it is a witness that you have provided, but they're being obstreperous in a way that they are not answering open-ended, non-leading questions, so you ask permission from the judge to ask leading questions that would normally not be allowed on direct examination. Now, that being said, it's always risky to put a criminal defendant on the stand. When your witness stops complying with your softball questions, you know you're in the danger zone and you really just have to cut your losses.
I'm gonna tell you exactly what kind of man you are.
No, you're not allowed to do that. You still have to ask questions.
You're the kind of man this city needs. Because, ladies and gentlemen of the jury, we all know this city needs help. Needs it now. Not tomorrow, not next week, not when the day comes when the corruption that Wilson Fisk left in his wake is...
Yeah, objection,
police forces
argument.
This city's been sick. And the cops, they can't fix it alone. We all need, men and women...
This is totally improper. 100% improper.
Their lives so that we can walk safe at night in our own neighborhoods. The ones our esteemed district attorney here is trying so hard to destroy. New York needs these people. We need.
It's hard for me to even watch this because it's so cringe-inducing. Oh, okay. And now we're gonna applaud the speech that's being made in the middle of a direct examination. The judge would not allow this. The prosecution would be objecting.
Your Honor, can I say something?
You may.
You know those people, ones that put down people I killed. I want you to know that I do it all again. This is a circus, all right? It's a charade, it's an act. It's about how crazy I am. I ain't crazy.
And that, ladies and gentlemen, is why you don't put a defendant on the stand unless you absolutely have to. Bad idea. Okay, that was the trial of Frank Castle in Marvel's Daredevil. A lot of good stuff, a lot of bad stuff. Definitely interesting to watch since I haven't seen it in a while. On the plus side, they have some really interesting arguments. They treated a witness as hostile in the correct way. They have some good back and forth about the different burdens that are required, whether you're the defense or the prosecution, and some interesting expert testimony. On the other hand, man, you can't make a speech in the middle of an examination. That's insane. There's so much procedurally going wrong. This trial would have taken months, and they're really just shortening it for dramatic effect, obviously. So overall, I give the trial of Frank Castle a solid C. It's okay, it needs some work, but it's entertaining.
All right, I get the hint.
You know, one way that Matt Murdock is able to accomplish so much in so little time is by listening to audiobooks. Lately, I've been listening to Marvel Comics, The Untold Story on Audible. It's an amazing behind-the-scenes chronicle of one of the most extraordinary, beloved, and dominant pop cultural entities in American history, Marvel Comics. It's the fascinating story of how Marvel went from bankruptcy to cultural juggernaut, pun intended.
I'm the juggernaut!
It incorporates hundreds of interviews with people like Stan Lee, Jack Kirby, and all of those people that work behind the scenes to create what Marvel Comics is today. It even answers some of the questions you never knew you had, like whose dumb idea was it to give Spider-Man a Spider-Mobile in the 70s? Why did Captain America, Iron Man, and Submariner suddenly all get solo titles in 1968? And why was Secret Wars such a terribly written story? Audible is giving legal eagles like you a free 30-day trial with 2 free originals to go with it, so you too can listen to Marvel the Untold Story. All you need to do is go to audible.com/legaleagle or text LegalEagle to 500-500. You can download any audiobook of your choosing and get 2 originals free. Clicking on the link really helps out this channel. So check out Marvel the Untold Story on Audible. Just head over to audible.com/legaleagle, text LegalEagle to 500-500, or just click the link in the description. Do you agree with my grade? Leave your objections in the comments, and check out this playlist over here with my other Real Lawyer reactions where I will see you in court.